Good morning and welcome to an oral argument session for the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over this case today and over this panel. We have joining us also from the 5th District, Judge Meredith Sasso, and we also have from the 7th Circuit, Judge Michael Orfinger, who's helping us out today. I want to thank Judge Orfinger for being a part of this panel today. The last case we have on the docket today is Maria, and I would totally butcher the name, so I'm not going to even attempt to say the name. Mr. Greenlee, I'll have you pronounce it for us, and then versus Federal National Mortgage, and I think it's Mr. Levine. Mr. Greenlee, I will assume that you would like 5 minutes for rebuttal, unless you tell me otherwise. And also wanted to, as my phone is ringing, I would like to encourage everyone to please put anything that makes noise on silent and or just mute your mic when you're not talking. But Mr. Greenlee, you may go ahead and proceed.
Good morning, Your Honors, and may it please the court. For sake of simplicity, we will refer to the appellant as Ms. Poche. I would like to reserve 5 minutes for rebuttal, if it pleases the court. Your Honors, the only issue before the court is whether the original party plaintiff, Aurora Loan Services, had standing at the outset of the case. We would submit that they failed to carry their burden that Aurora had standing. Under the UCC, 3 classes of parties are entitled to enforce a negotiable instrument. The second is the non-holder in possession of the instrument with the rights of the holder. And the third, in the case of a lost note, is the party that lost the note, but is nevertheless entitled to enforce it. In the complaint, the plaintiff alleged that it had standing by way of the first method, as the holder, but that theory fails as a matter of law. There was no blank endorsement on the note, on the copy of the note that was filed with the court at the outset. Aurora was not the original lender, and there was no evidence at trial that would establish when the endorsement appeared on the note. So Fannie Mae failed to carry its burden of showing that Aurora was the holder of the note. And it's also worth noting that Fannie Mae didn't even brief the issue on appeal, so we would submit that they abandoned that theory on appeal. There was no lost note.
They did say that at the inception, Aurora said that it did say the holder, but it also said it was the servicer, and that Fannie Mae was the owner. It doesn't sound like anyone ever tried to proceed under the theory that Aurora was actually the holder. It seems like they tried to proceed on the theory of a party in possession with the rights to enforce the note, because they said right out of the box that Fannie Mae was the owner and that they were the servicer. They did say they were the holder.
That's correct, Your Honor. I would make 2 points on this particular issue. First, as noted, they did use the word "we're the holder" in the complaint, and it doesn't say anything about being a non-holder in possession with the rights of a holder. It's also worth noting that those allegations that they are the servicer and that they were authorized to bring the foreclosure action, those are entirely consistent with the allegation that was pled in the complaint, that they were the holder. So they can be the servicer and also be the holder of the note, and they can be authorized to bring the foreclosure action and also be the holder of the note. So it's not as if that those additional allegations would put Ms. Corte-Real Poche, Ms. Poche, on notice that there was some alternative method of proving standing. So
not even by saying that Fannie Mae is the owner?
Well, they did say that Fannie Mae is the owner, but they also, again, that's consistent with the allegation in the complaint that Aurora was the holder of the note. So again, the complaint as framed led Ms. Poche to believe that this was either a constructive possession case or this was an actual possession case. And second, and maybe this point is more important, at trial, Ms. Poche moved for involuntary dismissal And Fannie Mae never said anything about its status as a non-holder in possession with the rights of a holder. And that colloquy is at page 832 and 833 in the record. And then in closing argument, and this is on page 882 of the record, counsel said, we put in our initial claim, plaintiff is the holder. And then they relied on an assignment of mortgage that, quote, transferred the note and mortgage from the original lender, First Magnus, to Aurora Loan Services. So that gives us standing on the day the plaintiff filed. So based on those statements, we would argue that at trial, they waived the theory that they're now advancing on appeal, that by virtue of the fact that we were the servicer and we were authorized to bring the note, that we had somehow had standing as the representative of the non-holder in possession with the rights of a holder.
What would be your response to an argument that issue was tried by consent, even if it wasn't specifically pleaded as a basis for standing at the inception of the action?
I would argue, and I think it's borne out by the record, that counsel for the defense objected, and he cited to the Angelini case, and he said, this is the case that was, pled as the holder, and all these other pieces of evidence that show the chain of transfer are irrelevant because they're proceeding as the holder. And under Angelini, those other methods those documents are irrelevant to the theory of standing that was pled. So I don't believe it was tried by consent. I believe that we lodged timely objections to the introduction of those evidence on the very same grounds that we're raising here on appeal.
Well, even though the word holder is in the complaint, doesn't that argument make us have to put blinders on to everything but the word holder and ignore the fact that Aurora also said it was the servicer and that Fannie Mae was the owner? And when you look at that in conjunction with the assignment, well, I'll leave the question as it stands.
Well, I don't think the court has to put blinders on, but I do think that, and this is something that we addressed in our reply brief, that under the principle of party presentation, the court is bound by the case presented by the parties. And again, during closing argument, the two theories that were presented were, number one, we're the holder. They reiterated that point. We're the holder of the note. And there's no evidence that they were the holder of the note at the time the action commenced. And then second, they said, essentially, we are a non-holder in possession with the rights of the holder. They said they transferred the note and mortgage from the original lender, First Magnus, to Aurora Loan Servicers. So that gives a standing the day the plaintiffs filed. And there was a motion to substitute party plaintiff that was filed. And in that motion to substitute party plaintiff, they attached an assignment of mortgage and the note that transferred any interest away from Fannie Mae. So that second theory, that it was
away from Aurora.
Away from Aurora into Fannie Mae. So it's our position that it should have been Fannie Mae and not Aurora. If they are relying on an equitable theory of ownership, it should have been Fannie Mae that filed the suit in the first place. And again, under the principle of party presentation, the court is not, at liberty to bypass a waiver or seek out theories of the case that would assist the plaintiffs. They have to take the case as it comes to them. And in this case, that's how the case came to them, is as either a holder of the note, or again, during closing argument, they said that we had beneficial ownership because they transferred. There was this assignment that transferred it from First Magnus to Aurora Loan Services, which I think was refuted by the evidence and testimony that came in at trial.
And of course, the court's order here notes that Fannie Mae was the owner and that Aurora was the servicer. Is it your position that it is not sufficient to just be the owner of the note, but there must be a finding in order to be the real party in interest that could assign it to the servicer, assign the right to bring the claim to the servicer, that Fannie Mae would then need to either be established as also the holder or the non-holder in possession in order to be able to validly assign the ability to pursue the foreclosure action to Aurora as the servicer?
I don't think there's anything, and I don't think the case law would really prohibit the representative of the owner from proceeding, provided that they pled that theory in the complaint, that I don't think there's anything that would prohibit Aurora from acting as the servicer on behalf of the equitable owner in the complaint. I think that there is support for that in the case law. But again, it's our position that that was never a theory that was advanced at trial. And arguably, because they said that they were the holder in the complaint, we think that they didn't adequately put Ms. Poche on notice.
And typically when those sorts, when it's pursued that way, there's a pooling and service agreement or some other form of evidence demonstrating the right of the servicer to pursue the foreclosure action. Was there that sort of evidence presented here?
There was testimony. I don't recall whether there was actually a servicing agreement or a pooling and servicing agreement. Perhaps my friend on the other side can correct me if I'm wrong on that. But I know that there was testimony, and it's my understanding that there also has to be documentary evidence to establish that they did in fact have the authorization to bring the action on behalf of the real party at interest. But I'm not, to answer your question candidly, I'm not sure whether that was introduced as evidence in the trial.
I don't think it was. But if you look at going back to the complaint, if you look at the complaint and take into account the fact that one of the attachments is the assignment from First Magnus to Aurora, doesn't it become apparent when you then read the allegations that that Aurora is acting on behalf of the owner?
Well, I don't dispute that they attached the assignment to the actual to the complaint. My understanding, though, is that the assignment that was attached to the complaint assigned the beneficial interest to Aurora. And again, if I'm misapprehend that point on the record.
Oh, you're right.
So that would be consistent with the theory that Aurora itself was the beneficial owner, the party at interest, and had standing to bring the foreclosure complaint on its own behalf. And it's inconsistent with the theory that it was bringing the foreclosure action on behalf of Fannie Mae. I would also point out that, words have legal significance. And when you use the word holder in the complaint, that signals, aha, that is the statutorily recognized form of standing that we are proceeding under. And if you were to alternatively allege non-holder in possession with the rights of a holder, that might be good enough, but that's not what we have in this case. And so we believe that the evidence was insufficient. And we also believe that the trial court was not at liberty to construe the evidence and make an argument that was really candidly never made by the appellee during the course of trial. If there are no further questions, I'll reserve the remainder of my time, Your Honors.
Mr. Levine, you may proceed.
Thank you. Good morning. Eric Levine here on behalf of Federal National Mortgage Association. May it please the court, the final judgment of foreclosure should be affirmed in this case. As counsel admitted, the sole issue is Aurora Loan Services standing to foreclose at the time the complaint was filed in November 2009. Your Honor, this case can be resolved by simple application of the standard of review, whether or not that was proven by competent substantial evidence based on the evidence presented to the fact finder who got to weigh the evidence, view the credibility of the witnesses, and make reasonable inferences therefrom. When Aurora Loan Services filed this action in November 2009, it alleged it was the holder of the note as well as the authorized servicer by the note owner, Fannie Mae, and this is exactly what was proven at trial. Fannie Mae introduced at trial unrebutted evidence.
Holder's a legally significant term, though, in the sense that it requires both possession of the note, but also an endorsement or blank endorsement would be in this case. Is there, in your view, any evidence submitted that there was a blank endorsement on the note prior to the commencement of the action?
Yes.
And what is that?
I have to admit, the evidence is circumstantial in this case because the clerk destroyed the original complaint that was filed and did not scan in the back page of the complaint, which would have shown the endorsement.
And that was specifically addressed by the trial court, right? And she said, based on latches, we're not going to talk about these additional pages that you're asking to submit as evidence. So taking the evidence on the record, is there anything other than those 2 remaining pages?
Yes.
Okay, what's that?
So introduced into evidence as Exhibit 6, I believe, was the servicing notes from Aurora, showing that Aurora was in possession of the original note as of October 22nd, 2009, which was before the complaint was filed. Aurora filed this action less than 1 month later on November 12th, 2009, and was in continuous possession of the note because it filed it on February 17th, 2010 with the trial court. And we know it was endorsed in blank as of February 2010. So as I said, it's based on a circumstantial, and they require the trial judge to make a reasonable inference.
And so there would have to be a presumption that the note was in the same condition and endorsed, and it was endorsed the same way it was in February 2010 as it was prior to the commencement of the action.
Yes, if you see.
And of course, the case law provides for such presumption, but the presumption in the case law for that is when the note attached to the complaint is significantly similar to the one that's filed subsequently.
I'm sorry, no, I'm not talking about what's known as the Ortiz presumption.
Right.
I'm talking about the trial judge as finder of fact's ability to make reasonable inferences from the admitted evidence before the court.
Okay.
In this case, the evidence established that Aurora was in possession of the note as of October 2009 prior to the complaint being filed. The record established that Aurora was also in possession of the note at the time it filed it with the court in February of 2010, at which time it had the blank endorsement. The servicing notes don't reflect any transfer of the note back to the original lender to be endorsed. So when you have possession in October 2009, and we admitted we don't have a copy of the complaint from October 2009, but we know Aurora had it the whole time, and it was endorsed as of February 2010, the trial judge, seeing this evidence, can make a reasonable inference that the blank endorsement from the original lender must have been there before Aurora obtained the note at least at the time Aurora had the note in October 2009.
Are you aware of any case in which that has been considered competent substantial evidence in Florida?
I know that there's case law, generally speaking, on the, I know there's generally competent substantial evidence, I know this case law talks about the trial judge being able to make the findings of fact and make reasonable inferences. I'm not familiar with any specific case off the top of my head where they talked about that, specifically talking about an inference of possession, but I think it's a completely reasonable inference. But even beyond that, the second aspect was the authorization. Mr. Greenlee, as I recall from his presentation, and certainly from his brief, doesn't dispute that Fannie Mae was the owner of the loan in 2000 when the complaint was filed. In fact, he said Fannie Mae should have been the plaintiff. And he doesn't dispute Aurora was its servicer at the time it commenced. So in addition to, I think, the proof of holder status, Judge Sasso, but if you think that proof is lacking, we still have proof that Aurora was the authorized servicer for the note owner at the time the action was commenced.
And isn't that just another expression of non-holder in possession of the rights of a holder?
The case law, as well as the statute, doesn't really define what non-holder in possession with rights of the holder means, but it is kind of in my opinion, kind of a catch-all that says, if you're not the holder because you're not in possession of a blank endorsed note, you can explain through other evidence why you have those rights a holder would have, even though you are yourself not a holder. So yes, if you're the authorized agent for the owner, then you yourself could be considered a non-holder, but with the rights of the holder. And Ms. Pucce's own conduct contemporaneously with the complaint being filed shows he really doesn't dispute Aurora's standing. Entered into evidence as Exhibit 2 was a letter from Ms. Pucce to Aurora dated February 2009, talking about how she wanted Aurora to give her loss mitigation effort. So clearly She knew Aurora was her servicer. She knew Aurora had the authority to deal with her with respect to her loan. Aurora could not give her the relief she asked for in that letter if it didn't hold the note, or at least was authorized to do so. And in this case, Judge, I think, as I said when I first started my presentation, this comes back to the standard of review. The burden of proof in civil cases is by a preponderance of the evidence. We don't need to prove Aurora's standing beyond all doubt, or beyond all even a reasonable doubt. Just by a preponderance of the evidence presented, did the trial court find that Aurora had standing to enforce this note? And I think that's an unequivocal yes. The evidence clearly showed Aurora was in possession. That is direct evidence, Judge Saffold. There is direct evidence of possession of the note. There is very strong circumstantial evidence of the note being endorsed in blank at the time it was filed, if not direct evidence of it. And there's undisputed evidence that Aurora was the servicer of the loan for the note holder. That evidence, taken through its totality, is fully supportive of the trial judge's factual findings.
Go ahead, sorry.
Did he argue at trial? Did the defendant's counsel argue at trial that there was this strong circumstantial evidence of the endorsement being on the back of the note?
I'm not
filed, because I don't recall that from the transcript.
I'm not sure if I recall that either from the transcript, but when looking at the evidence and this court's review as to whether or not the judgment could be supported by any reasonable view of the evidence, I think that the trial judge did make the factual finding that Aurora was in possession of the note. The trial judge did make the factual finding that Aurora was the authorized servicer for the note owner. And the evidence does show a reasonable inference could be drawn based on the circumstantial evidence that it was endorsed in blank at that time as well.
You would agree, though, that there's no factual finding that it was endorsed in blank at that time?
The judge did not make the factual finding as to the blank endorsement. She made the factual finding of possession she made the factual finding Aurora was in possession. She made the factual finding Fannie Mae owned the loan, and she made the factual finding Aurora was authorized servicer. That was sufficient in itself to find.
So let's say that we disagree that is one, that we could make that factual finding that would be appropriate for an appellate court to make the factual finding about that the circumstantial evidence is sufficient to demonstrate that there was an endorsement on the note. It's your position that that is irrelevant, or it is not dispositive because Aurora is the servicer?
That's correct. So let's put that aside. Let's assume that the note was not endorsed at case inception. Well, let's take that as a momentary given. The evidence still showed possession of the now unendorsed note. The evidence still showed, and is undisputed on appeal, that Fannie Mae owned the note. And the evidence still showed, and is undisputed on appeal, that Aurora was the servicer for the owner of the note. Taking this evidence, the trial judge found that clearly Aurora was the proper party to file the action to begin with.
And how is that consistent with the statutory language?
It's consistent
that it's either a holder or possession, or a non-holder in the rights.
Well,
a non-holder in possession of the rights of the holder. And again, holder assuming that there's an endorsement.
If they're not the holder of the note, then the non-holder in possession with rights of a holder allows the plaintiff to explain how they have standing to enforce the note. And in this case, if the note was not endorsed, they nevertheless established that through the ownership of the loan by Fannie Mae, and ownership of the loan requires Fannie Mae at least have received an equitable transfer of the note, if not a endorsed note. And Fannie Mae then delegated the authority to enforce to Aurora. And as I said,
wouldn't that also require, though, proof of the origination of the note all the way through Fannie Mae's, in other words, each step of the assignment of the note to Fannie Mae in order for Aurora to appropriately proceed to commence the foreclosure action as a servicer?
In this case, under the facts of this case, I might have said yes if the issue was properly preserved. But in this case, since due to the admissions in this record that Fannie Mae is the owner, of the loan, since that is not disputed, I don't believe is preserved for the chain, the requirement of the chain of possession or the chain of sales is before the court. The initial brief says.
You would agree though, holder and owner are legally significant terms, or
Yeah,
distinguishable terms.
the owner can be the holder, but does not necessarily have to be.
No, but for standing, there does need to be proof of a holder,
Well,
right? Either through the chain of assignments or through the endorsed in blank. No.
yeah, you could have one or the other, or you could have both. As I said, I think in this case we established both. But if we want to say we didn't establish the endorsement, since there's undisputed that Aurora got an assignment prior to the action being filed, it's undisputed Fannie Mae owns the loan. It's undisputed Fannie Mae authorized Aurora. Based on this evidence, and obviously I know Judge Sasso, the evidence could have been better. It would have been great if the blank endorsement was reflected on the complaint, but the burden isn't on us to prove this beyond a reasonable doubt or beyond all doubt. But does the evidence presented prove by a preponderance of what's been given? And since 100% of the evidence is from us showing our standing and there's zero contrary evidence, I think by a preponderance, the trial judge's decision is supported and should be affirmed.
Well, you don't become a holder by reliance on assignments, do you?
Generally not. I mean, there is an argument that I typically don't make. There is an argument that an assignment reflects an equitable transfer of the note, or at least a intent to transfer, and it's that intent that transfers it. I typically don't make that. I'd much prefer to prove actual possession than intention or the intent to transfer. But an assignment of the note at least shows that there was that intent to give the note to Aurora, which of course is not disputed here.
Well, you can establish ownership that way, and you only have to be the owner or the holder.
That's correct.
Supposedly.
And in this case, I think we've established both, but at the very least, we've established Aurora as the authorized servicer for the owner, Fannie Mae. And if there's no other questions, I'll rest on that and ask that the final judgment of foreclosure be affirmed.
Okay.
Thank you, Your Honors.
All right. Mr. Greenlee, you have a little over seven minutes.
Thank you, Your Honors. I won't use all of it. I just have a couple brief points here from my notes. First, I would submit that the term non-holder in possession with the rights of a holder is not a catch-all phrase. It typically denotes equitable ownership as evidenced by a chain of transfer from one party to the next, all the way down until you get to the party that's bringing suit. I think typically when these cases come before the court and it's the servicer is bringing the case on behalf of the other party, that party is typically the note holder. And so that would fall within the first way of establishing standing as the note holder. Now, we clearly don't have that here. There is a long line of cases that says that where there is an undated endorsement in blank, we can't presume that it was that was a condition of the note at the time it was filed. So I think that if the court were to hold otherwise, it would fly in the face of many cases. That
What is your response to Judge Orfinger's question that one can either be the owner or the holder to foreclose? And forgive me if I misstated that question.
We don't dispute that as a general proposition. We think that there are our first argument is that they never pled that we're the non-holder in possession with the rights of a holder. The second argument would be, again, at trial, they said that there were two theories advanced during closing argument at trial. One, there was the holder. We don't think there's competent substantial evidence on that point. And before I miss this point, possession is irrelevant unless there is a blank endorsement. You can be in possession of a note, and unless it's endorsed in blank, that possession, that doesn't matter at all. So the court made the finding that they were in possession, but that finding doesn't assist them in any way. The other point is during the course of trial, they made an argument that they were the beneficial owner. They said that we rely on this assignment from from First Magnus to Aurora. And that was completely discredited by the assignment that the trial court took judicial notice of, that showed that prior to the inception of the case, Aurora transferred its beneficial ownership away from itself and transferred it to Fannie Mae. So that second theory of standing, pardon me?
Took judicial notice of the document to the extent it was in the court file, but she also said it was hearsay.
Well, if it was here, pardon me, Your Honor.
Not giving it evidentiary weight because it was hearsay.
Yeah, thank you, Your Honor. I am glad to address that point. We think that, as counsel argued below, that it was a nonverbal act with legal significance, so it's non-hearsay on that basis, and there's many cases that say that. And maybe more importantly, they relied on that very same assignment to obtain a substitution of party plaintiff. So I think it would make a mockery of the proceedings to allow them to dispute the validity of that assignment later on when the case came to trial. I think that principles of waiver and estoppel should prevent them from making that argument.
But it was the defendant who objected to its admission as hearsay, was it not?
I don't believe. I think the defendant was the proponent of that piece of evidence. The defendant was trying to introduce that I didn't. When I reviewed the trial transcript, I didn't see that the defendant. There was many objections based on hearsay lodged at trial, but I don't think to this particular document, particularly since the defendant was the proponent of this document, that hearsay wasn't an objection that was lodged by the plaintiff or the defendant. And if I'm wrong on that, I apologize, but I didn't catch that in my review of the trial transcript. One final point regarding the standard of review. It is true that if there is competent substantial evidence, that the judgment should be affirmed. We agree with that as a legal proposition. We just don't think that there was any competent substantial evidence that suffices under the existing case law that would satisfy the allegations in the complaint that they were the holder of the note. That is a term of legal significance. Ms. Poche had every right to rely on that when she proceeded to trial, and she disproved that theory at trial under longstanding precedent. An undated blank endorsement, if it's not consistent with the copy of the note filed at trial, is insufficient to establish that they had standing at the outset of the case. And with regard to the unpled theory that they were the servicer and therefore they had standing as a servicer, as an initial matter, there is no. The statute doesn't say, well, there's a fourth way that you can prove standing, and it's as a servicer. I think if you are proving standing as a servicer, it still has to be kind of as a derivative standing from one of the three statutorily recognized forms of standing that are codified in the statute. And we don't believe that they proved the only method of standing that they alleged. And so we would ask the court to reverse the entry of final judgment and remand for the entry of an order involuntarily dismissing this action.
Okay, thank you for your arguments, counsel. And with that, we are in recess.